Again, thank you for joining us for the care and feeding of your Revocable Living Trust with John Dunnell, the senior attorney here at Generations Law Group, specializing in tax and trust administration. We are recording this webinar. Again, please put your questions in the chat box. I'm going to share my screen and I will turn it over to John.
Good afternoon, everybody, and thank you for joining us on this hot and humid summer afternoon. I think almost the first day of summer. Thank you for being here. My name, as Tiffany introduced me, is John R. Dunnell. I'm a senior attorney with Generations Law Group with offices in Acton, Andover, and Sudbury. I'm currently in a little satellite office in neither of those places, but I'm happy to join all of you here for a little chat about our topic, which is the funding, the care and feeding funding of your revocable living trust. So we'll jump right in with the first slide. So our topic, care and feeding of your revocable living trust. There I am. Next slide. A little disclaimer here. This presentation is meant to be a general overview of estate planning and should not be considered as legal advice. You should consult an attorney in your state to determine the legal requirements for your individual situation. Next slide. So, as I said, our topic today is getting your revocable living trust to actually work for you. So we want to start with the main question, which is, what is a revocable living trust? Well, a revocable living trust is a legal document that allows you to place into it during your life certain assets that you want to pass to your loved ones at your death. Typically, you, or if you're married, you and your spouse create the trust and name yourselves the trustees of the trust until your death or sooner incapacity, at which time you've named a trusted person, perhaps a child, to act as your successor trustee to take over for you to administer and distribute the assets of the trust when you no longer are able to do so or you've passed away. The trust is revocable, meaning that you or you and your spouse, if you're married, can revoke the trust or amend its provisions as long as you are able to. And it's referred to as living because it's something you create while you are alive. Like a will, a trust is designed to pass assets to your loved ones at your death, but it is more efficient and less costly for passing assets at your death than a will, because wills must go through a probate process at your death in order to become effective, whereas the trust does not. Next slide. So why do people want to create the revocable living trust? The answer is in two words, generally: avoid probate, which then leads to the question, why do we want to avoid it? Which then leads to us asking, first, trying to get an understanding of what is probate in the first place. So once we know what probate is, maybe we can understand why it is we might want to be avoiding it. So what probate is a court process by which a deceased person's estate is administered and distributed. It involves validating a deceased person's will before those assets can be distributed by the will to the deceased person's family. In most cases, we want to avoid this process because of the length of time that's involved in the probate, the significant fees and costs that are generated in terms of legal fees and court costs, as well as the public nature of the proceeding. Because a trust can do everything that a will can do at your death, and in particular, passing assets to your family, but it can do it more quickly, less costly, and in private. That is, again, without the resort to the probate court. Next slide. So creation and funding. You may have already created a revocable living trust with your lawyer as part of your estate plan. If you have not done so already, our office can help you with this. We can help you establish one. And if and when you've created your revocable living trust, a question is that do you simply then put it away like your will and wait until you've passed away for it to work? Well, the answer is no. You need to do something more after you've created your revocable living trust. What you need to do in order for it to serve one of its essential purposes is to fund it. Next slide, please. So, what does funding a trust mean? Well, we might use a comparison to a safe. A safe only protects what you put inside of it. Similarly, a trust can only pass assets at your death without probate if you put assets in the trust. So funding means putting assets into your trust. This involves retitling an asset from your name individually, or if you're married, from your and your spouse's name to the name of your trust. You can think of it this way. You go out and you buy a safe, you spend some good money for a really good one. You do the same with your trust. You go to a good lawyer and you pay good money to put in place a trust. After you buy the safe, you wouldn't simply leave it empty forever, never putting anything in it. One would ask the question, if you did that, why did you buy the safe in the first place? Similarly with the trust, you wouldn't take the time to create it, spend some good money with a lawyer on having it executed, and never go about funding it. So the visual we're looking at here is like a safe. You want to put things in your revocable living trust. And what we're going to be going over in some more detail in a few minutes is what those things are. But you can see on this slide, it's your investment in bank accounts, personal property you may have, in real estate. Again, you need to fill the safe. You need to fill the trust in order for both to work properly. Next slide. Now, I suppose when I look at this slide, I think maybe this person here has done their own probate avoidance, maybe sticking cash under the mattress. We've heard about this. I've never personally seen it, but I suppose that's a way of avoiding probate. Cash is there for the family to go and collect. It's not recommended. Lawyers don't recommend that, but I suspect that perhaps sometimes that's done. But for our purposes, we want to know, why would funding your trust as the means of avoiding probate matter? Why does this matter? Again, because assets in your individual name at your death pass by your will, they require a probate process involving the courts. Because it does, you need to hire and pay a lawyer to help you get through the process. And as I alluded to, this process moves slowly. And in terms of the second bullet you see on the screen here, because the court is a public place, the provisions of your will and the assets passing by it become a matter of public record. Whereas with a trust, your trust stays privately between you and your loved ones. It never has to get filed with a court. On bullet number 3 here, a trust can do something also that a will can't do. If you have assets in your trust and you became mentally incapacitated, the trustee you've named to succeed you can seamlessly access those assets without having to go to court first. Because they're named in the trust document to succeed you, the successor trustee can take over without any interruption in terms of access to the assets. Talked about the cost savings already. Not having to go through probate saves time and money. Lastly, simplifying administration. Having assets in your trust make things easier for the person you've named to be in charge after your death. This is the person we call the successive trustee, the person that would follow you or you and your spouse as the trustee. Perhaps it's a child. You've enabled this child to access your assets without initiating a probate proceeding. This way they gain access to the trust assets, in many cases within days, if not weeks, instead of through a probate process as much as several months. Next slide. So we're going to get into the funding of our trusts in the real world. What is it you really got to do as a practical matter to make your revocable living trust work? As we pointed out in the first bullet, we don't want to just set it up and forget about it. That's a misconception. Unlike a will, we need to do something. But the question often can come up is, does every single asset you own require a trust in order to avoid probate? And the answer to that is no, not all assets do. Which ones do not or may not? First category of assets would be assets that you own with another person. If you owned an asset such as your home or a bank account jointly with your spouse or child, and you died survived by that spouse or child, then the asset would be solely owned by that spouse or child with nothing more needing to be done. However, if your spouse or that child predeceased you, then on your death, probate would be required to get that asset to your loved ones, because it would be then standing in your name alone, in which case it would have been better to have had the asset titled in your trust, as we will see. Another category of asset is assets for which there is a designation of beneficiary. Many assets, such as life insurance and retirement accounts, meaning IRAs and 401ks, give you the option to designate a beneficiary as part of the contract with the provider of the asset, that being the life insurance company or the custodian of the IRA. And consequently, if you simply designate a person or persons as beneficiary, then the asset will pass directly to that person or persons at your death without probate. But again, as with jointly owned assets, where the person you own the asset with could predecease you, the beneficiary you've designated for your IRA or life insurance likewise could predecease you, in which event you would have no named beneficiary, and the proceeds of the life insurance or the IRA account balance would then need to go through probate. So if instead you had named your trust as beneficiary, because the trust can't predecease you unless you revoked it, the trust will be there to collect the asset on your death without a probate proceeding. Now, before we move on, there's an important reminder that sometimes you don't often think about or you wouldn't know. When you do your estate plan with your lawyer and you have done a trust or even a will, if you didn't do a trust, you would designate life. You would also have the beneficiary designations, perhaps, of your IRA, life insurance. If those differ from what you've done in your will or trust, the question is, does the will or trust still control? So for example, you do an IRA designation of beneficiary naming child X. but in your will or your trust, you said, I want all my assets to go equally to my children, X, Y, and Z. Where will the IRA account balance go on your death? Will it go the way you stated in your will or trust, or will it go the way you have stated in your designation of beneficiary? The answer is it'll go the way you've designated in your beneficiary form. The IRA account will go the way you've stated in that beneficiary form, meaning what you do in your beneficiary designations trump what you do in your trust or your will. It's an important reminder that when you're doing your estate planning, you want to be thinking about all of your assets in tandem and coordinating as part of your overall plan where those assets are going to go. Next slide. So let's look at the common assets that should be titled in a trust. Many assets do not provide an option for designating a beneficiary or are just not good candidates for being held jointly. With respect to assets such as that, I'm going to use an illustration for talking purposes. We're going to think of John and Jane Smith, who have done a revocable living trust with their lawyer, and they've entitled it the Smith Family Revocable Living Trust, dated June 19th, 2025. And they've named themselves the initial trustee of their trust, and they've designated someone to succeed them as trustee so that on their deaths, that person can take over. That'll be their son, Randy Smith. Now, with that in mind, we can talk about asset by asset. We see the first bullet point on our screen here, your home and other real estate. There's something about real estate, especially in Massachusetts and most states, unlike life insurance or retirement accounts, it doesn't have a designation of beneficiary associated with it. You can't designate on a form the beneficiary of your home. Instead, it's governed by a deed. And in order to avoid probate, what you would want to do is have the deed changed. The deed, again, is the paper that shows who owns your real estate. Currently, it may show that you or you and your spouse, if you're married, own it. But instead, in order to avoid probate, you would want your trust to be the owner of your real estate. Now, you'd need some legal assistance with that. You'd hire a lawyer to redo the deed for you, and our office routinely and can assist you in this process. An example of how your deed would read is, using John and Jane Smith as our example, John and Jane Smith, trustees of the Smith Family Revocable Living Trust, dated June 19th, 2025. You would have the deed prepared that way, you would sign it, and you'd record it, or have your lawyer record it for you at the Registry of Deeds, along with what is known as a certificate of trust, wherein recorded at the Registry of Deeds, there's sufficient proof of who's in charge of your trust without revealing the entire trust document to the public. So the Registry of Deeds sees a certificate of trust showing John and Jane Smith in our example as trustees, and showing Randy Smith as the successive trustee after them, so that third parties dealing with the real estate in the future, like a future buyer, will know with certainty who they can be dealing with on behalf of the trust. And if the real estate that you're putting into your trust is your home, then at this time you would also want to do a homestead declaration. Even if you'd done one before, because now the title is changed to your trust, so you'd be redoing the homestead declaration in order to continue to keep the home protected from creditors, which is the purpose of the homestead declaration, and a topic perhaps for another day. Next bullet on our slide is bank and investment accounts. This is another significant asset that you would have that you'd benefit from having held in, excuse me, your revocable trust. With respect to these assets, you would go to your bank, or you'd get the help of your investment advisor if you have one for this process. You would need perhaps a copy or the original trust instrument to share with the bank or investment advisor so they can see that it does exist. But perhaps in lieu of that, keeping the contents of your trust private, you could provide the bank or investment company a certification of your trust. Similar to what I just mentioned, you'd record at the Registry of Deeds. Your attorney with you could have a certificate of trust drawn that can be accepted by the bank or investment company in lieu of the trust instrument itself. Again, that certification of trust indicating all the relevant information for the bank or investment company. Most importantly, how it's titled. And again, just like the title to your deed we've just talked about, using John and Jane Smith as our example, John and Jane Smith, trustees of the Smith Family Revocable Living Trust, dated June 19th, 2025. Now, when you're doing this, the bank or your investment advisor may request of you a tax identification number for your trust. As long as you or your spouse, if you're married, are one of the trustees of your trust, you can tell them that the number is your Social Security number. This is because the IRS does not require, nor does it want to see, a separate tax identification number for reporting the interest, dividends, or capital gains from this account that is in the name of your trust. The IRS expects to see, and you'll continue to report as you were before, the interest, dividends, and capital gains on that account, even while it's in your trust, under your Social Security number and on your own personal income tax return. Lastly, when you're dealing with bank and investment accounts, be your best advocate. Dealing with financial institutions can be difficult. Where you have an investment advisor, you can enlist their help in getting all of this done for you. Where you do not, or where you are dealing directly with a bank, just be prepared in advance when you go there. Have an original of your trust in case they want to see it. Many times banks want to see the original trust instrument. If you have a certificate of trust, like I've talked about, prepared by your lawyer for you, you can bring that certificate of trust with you to the bank. And if your lawyer has given you specific funding instructions, you can bring those as well to be able to refer to when you're meeting with the bank representative. And just be confident in knowing that when you're there, that once your revocable living trust was created, you can title anything in the name of it, even if the bank rep or investment advisor might be doubting that. Yes, you can, and just be confident in knowing that. Now, we talked before about life insurance and retirement accounts. How either of these can use a beneficiary designation and not have to rely on a trust in order to avoid probate. We mentioned earlier that if you've named somebody as beneficiary and that person survives you, that the life insurance proceeds or the account balance will pass to the person you've designated. But we also talked about if that person happens to predecease you, then you're back in having to go through a probate. So often for that reason, it can be better to name your trust as beneficiary of your life insurance. And there's two other instances as well, where naming your trust would be the better option. Naming your trust as the beneficiary, that is. First, if the person you want to leave your life insurance proceeds to is a minor or a disabled person, then you would be better to leave the life insurance proceeds designating your trust, wherein you can make special provisions for that minor or disabled person. Second instance would be by naming your trust as beneficiary of your life insurance proceeds, you would be providing the person you have named to succeed you as trustee, your successor trustee. In this case, we've been talking about John and Jane Smith, their son Randy, the person in charge. You'd be enabling that person to access needed liquidity at your death to pay expenses such as funeral bills, legal and accounting fees, and any taxes that may be owed after your death. In order to designate your trust as beneficiary of life insurance, very similar to how you titled your home or you've titled your investment or bank account. In our example of John and Jane Smith, trustees, but we would add John and Jane Smith or their successors in trust as trustees of the Smith Family Revocable Living Trust dated June 19th, 2025. We just add or their successors in trust, really recognizing that by the time the life insurance proceeds are going to be paid to the trust, both John and Jane Smith will have already passed away. So we're really focusing on their successor in trust. And you might say then, well, why don't we just say Randy Smith, their son, as successor trustee of their trust? Well, the answer to that is that if someday you want to change your successor trustee from Randy to your other child, David, you don't need to go back and change your beneficiary form again because you've named Randy on the beneficiary form. If you leave it vague, open, whoever the successors are, you can make that change in an amendment to your trust without also having to go back and change your designation of beneficiary. Retirement accounts we talked about earlier, IRAs, 401ks, and the like life insurance, have designations of beneficiary. Unlike life insurance, however, in the instance of life insurance, when your beneficiaries receive the policy proceeds, those proceeds are free of income taxes. Life insurance proceeds are not subject to income tax when they're received at your death. Retirement accounts, IRAs, and 401ks are subject to complete income taxation when they are received after your death. It is for this reason, this difference in most cases, you want to be sure not to name your trust as beneficiary of your 401ks and IRAs. And the reason is, amongst others that are too detailed to get into in the time we have today, is that trusts pay income taxes at very, very, very high rates as opposed to individuals. So if you pass taxable income, such as IRAs and 401ks through your trust, you can cause taxation at a much higher rate, in essence, giving more to the government than to your family. Safer approach, unless you meet with a lawyer who gives you reason otherwise, name an individual as beneficiary of your retirement accounts. What about other assets you may own? As I said earlier, anything can be titled in your trust. Your stocks and bonds, if you have stocks and bonds, Series E bonds, Series I bonds, for example, valuable collections that you have, and interests you may have in businesses, such as S corporations. If you have an interest in an S corporation, or you have an interest in an LLC or a limited partnership, those interests can be titled too in your trust. And then last but not least, what about your car? Well, with a car, dying owning this asset usually does not require a full probate. Instead, there's a simplified administration process called voluntary administration to handle this. But you can, like I said earlier, you can even this asset have it titled in your trust. You need to go to the Department of Motor Vehicles, DMV, in order to change the title. They would need to change the certificate of title for you. But in many cases, my experience is people don't. Often the thinking is, this is not the car I'm going to die owning. Or in some cases, if you own the car long enough and you get old enough, your kids might take the car away from you. And we've seen that in plenty of situations. Next slide. So let's think about also, as you're funding your trust, what are some good practices, best practices? First, very important is to try to be organized, try to keep detailed records. Make copies of all statements and titles that show your trust as the owner of the assets that are in the trust. Keep these statements together with your estate planning documents, your trust, your will, your power of attorney, your healthcare proxy. Try to keep them all together so that your family can find them. Often it's a good idea to have them in a binder, everything in one place. If you do a comprehensive estate plan with Generations Law Group, at the end of the process, we offer holding your originals to safeguard them for you. In exchange, you get a handsome binder, hardbound and with 3 rings, to keep all of your papers you've had done with us, as well as indexed sections of the binder for putting things like a copy of your deed showing the trust owns it, or beneficiary designations showing you've designated your trust, so that everything's all in one place. Next bullet, we're all busy. And I recognize with my clients when I've met with them, I know you may not get to the car, you may not get to a small bank account. So we want to prioritize. We want to go big to small. Attack the big assets first in terms of getting them to avoid probate, getting them in your trust. Your real estate, you might do first. Your large bank or investment account holdings, tackle those first. And when there's new acquisitions, keep them in mind. Maybe at some point in your life, you'll buy a second piece of real estate. Maybe you'll sell your home, and you'll buy a new home or a condo. When you buy that new piece of real estate, for example, if you think about it ahead of time, let the closing attorney know that you don't want to take title in your individual name. You want to take title, John and Jane Smith in this example. They want to take title to their newly purchased real estate in the name of the Smith Family Revocable Living Trust. They can let their closing attorney know that ahead of time. The closing attorney can prepare the deed for them accordingly at no additional cost to them. Working with the right professionals, really important. You, at any given time in your life, may have 2 or 3 important professionals working in your best interests. Your lawyer, your accountant, and perhaps also, too, you have a financial advisor. Consider them your team. And consider not isolating them separately in dealing with them. Consider, from time to time, involving them in meetings so that one hand does know what the other hand is doing. Particularly if you have a financial advisor, letting them know you've done an estate plan, letting them know you've done a revocable living trust, so that they will be in a position to give you suggestions and guidance about how the assets you are investing through that investment professional can be retitled in your trust. And lastly, it's good to have a regular review schedule. Things change over time. Good to meet with your estate planning lawyer periodically. Not has to be every year like you might with a financial advisor, but a good rule of thumb is every 3 to 5 years, because over that course of time, things can change in your family. Certainly, the scope of your assets or the type of assets might change, and sometimes there can be significant law changes over that period of time. Next slide. And as we alluded to, you want to let the important people know of your estate plan. Talked about financial advisor, your accountant, perhaps also your insurance agent, although not always necessary. Certainly, number one on the list, even though it's the fourth bullet, is the close family members. They should know. Now, do they need to know all the details of what you've done? No, if you don't want them to. You can, but you don't need to. But at a minimum, you want them to know that you've done these documents. You've done a revocable living trust, as well as a will, a durable power of attorney, healthcare proxy. You want to let them know where to find copies, or where to go to get the originals if they're with Generations Law Group, to let them know, to contact the firm to access the originals, and where in your house to go to find your copies. And very practically, to make sure at least one of those people has a key to your house so that they can get into your house to get to these documents. And if they're locked in a safe box somewhere, or they're in a safe deposit box at a bank, to make sure that at least one of these people has a key and can access these important papers. Next slide. So 3 common mistakes. 2 of them we've talked about. Bullet 1, bullet 3, fairly the similar issue. Setting up your trust and then never doing anything with it, leaving it empty, like your empty safe. Don't want to do that. We want to fund. Sometimes you can go to the nth degree and put too many things into a trust. Are there certain times that you would want to leave well enough alone and not put the asset in the trust? Well, a good example, couple good examples of that are, one, with regard to your retirement accounts. So let's say an IRA. The IRA should always be titled in your name. You'll designate a beneficiary, an individual, as I suggested, better than your trust. But you'll make a designation of beneficiary, but you will not ever retitle that account in anybody's name but your own, because that would trigger an immediate income taxation of all of the holdings of the IRA. Now, it's not that easy to do that. There's safeguards against you doing that, but there's just one example of leaving well enough alone. The IRA always stays in your name. You designate the beneficiary, you keep the ownership with you. Another very practical example of something you may not put in your revocable living trust is a bank account that you have set up with direct deposits and electronic withdrawals, direct deposits of your Social Security, pension, electronic withdrawals monthly of your bills. You spent a lot of time setting that up. You don't really want to go close that out, set up a new account, and have to go and do that all over again. Better would be to keep that trust of a modest, account of a modest amount, maybe add a child to it, and use your larger bank accounts or investment accounts to be in the name of your trust. Next slide. So, when is it a good time to get some help with this process? Well, if even after this webinar, you're not sure what or how to move something into your trust, I hope that won't be the case, because I hope I did a good enough job to give you an idea on that score. But if you're not sure, never hurts. Have a consultation with your attorney and get help where you need to. As I said, you would need an attorney to do a deed of your real estate to your trust for you anyways. And maybe during the course of that representation, there might be other suggestions with regards to other assets. Of course, whenever you want to make a change to your revocable living trust, you should see your lawyer to make those changes for you. And specifically, if there are tax questions you have, we touched on some of them today, whether to name your trust beneficiary of your IRA or whether to name an individual. Consult with counsel who has a background in taxation. One of the positions that I have with Generations Law Group is to add that to what we offer. I have a significant tax background, and if you have questions regarding taxation in general, even beyond your trust, feel free to contact me and arrange a consultation to go over those questions. And of course, if there are major changes in your life, such as losing a loved one, losing a spouse, that is a good time to do a review with your estate planning counsel. And absent any of those, just regular review, like I said, 3 to 5 years is a good idea to make sure that everything is up to date. Next slide. So, in summary, a revocable living trust is a great tool to help your family after you're gone, but it only works well if you fund it. Moving things into your trust, keeping good records, and reviewing it regularly, your family will thank you for taking these extra steps, and by doing so, you will be making their lives easier during a very difficult time. Now, as the screen says, questions, and we've got as much time as you need, I think, at least up till 2 o'clock, for me to try to answer as many questions as I can. So let's go.
Okay. I see some great questions in the chat box, so I will start at the top. The first question is, will assets and property put into a revocable living trust protect them from being taken by nursing or assisted living facilities, should that level of care be needed?
Unfortunately, no. One of the main purposes, as I mentioned, of a revocable living trust is avoiding probate. It does that very effectively, but is not also trying to do more than that, such as protecting the assets of it from the costs of long-term care. Reason being, just to put a little bit of a reason behind that, but might make sense, is because of what I said at the very outset. You are the trustee of your revocable trust. You can revoke it, meaning you put assets in it, you can just as easily take assets back out of it. And because you have that level of control, it is not protected from the costs of long-term care, nursing homes, and otherwise. It's a trust, yes, for those kinds of things. And you've probably heard this, but it's a different kind of trust. The important word, irrevocable trust rather than revocable. And in that instance, irrevocable, and you're not one of the trustees.
To add to that, and something that John had mentioned, he gave us a visual of a safe for a revocable living trust that you can put things in and take things out. And we like to think of an irrevocable trust as a vault. It's locked in. If the visual helped. Okay, the next question is, first, thank you for the outstanding presentation. Please confirm that a life insurance beneficiary can be your own name. That is, the policy is for, as trustee of the revocable trust. It makes sense on one hand, but also seems somewhat counterintuitive.
Okay, if I think I understand that, first of all, let's talk about the ownership. The life insurance certainly can and typically is owned by you, the insured, the individual insured. The designation of beneficiary, as I pointed out, does not need to be the trust to avoid probate at a very basic level. The considerations I gave for naming a trust as beneficiary being the examples being the person you name may predecease you, having a beneficiary you're trying to benefit who's a minor or disabled person, and this idea of, as part of your overall estate plan efficiency, creating a situation where money is immediately available to the person who succeeds you, the successor trustee of that trust. Now, if I'm hearing the question correctly, maybe part of the idea here is like, well, if you're naming your trust is you. I don't know if that, Tiffany, if I'm getting this wrong, you can correct me. Maybe it sounds counterintuitive that you would name yourself as trustee of your trust as the beneficiary of your life insurance. But again, that's where I was referring to the fact that you might name yourself, but you want to make it very clear, more importantly, that the beneficiary will be your successor trustee under your trust document, who's collecting that life insurance proceeds. Did I cover that adequately, or did I miss something on that, Tiffany?
I think you covered it. And then for the person who asked the question, I just copied the wording that John was talking about, where it's you as trustee or the successor trustees. So I don't know if seeing the wording again clarifies it a bit better, that you don't want to give up that control. So you don't want to immediately go to the next person. Like when John said he wouldn't instantly go to the son Randy. So maybe seeing the writing as John and Jane Smith or their successors in trust clarifies. I don't know if that helps any. He can write back if it's not quite clear. There's a question about what is the impact of moving out of state.
No, that's an excellent question, and comes up very often in our meetings. Um, if the trust is basic enough, if now you may be doing other things with your trust that we couldn't get into today with time constraints, but maybe it'll be a topic for a future webinar. But if the revocable living trust you're using is for its most basic and only for its most basic purpose of being a will substitute, something that allows you to get the assets to your children without having to go through a probate process, which is what we've been talking about today, then in most cases, that revocable living trust is going to be easily transferable to other states. It's not going to be violating other states' laws. It's going to work within those laws. It's going to be understandable by the attorneys in those states who may be trying to help your loved ones after you've passed away. Nevertheless, it is a good recommendation. I make it, and I'm sure that most attorneys do, that when you get situated in that new state, at least have qualified counsel in that state. Maybe you'll get a referral from your neighbors who you've moved next to, or friends or family who live in that state, to take a look at what you've done and just make absolutely sure there's not something else that might be done to your revocable living trust. I don't think often it has to be a complete restatement or doing it over again. It might be just tweaking a thing or two based upon specific state law. Hope that answers your question on that.
And I think that ties into, I'm going to skip the next question, but I'll come back. But the next one down actually, I think, goes with possibly reviewing it if you move out of state. But how do you minimize Massachusetts estate taxes?
Okay, this is going to be definitely something I'd be very excited about offering the next webinar I do. And I think that's November, so you can tune in then. But yeah, so, one of the purposes, if we want to think about what I've talked about today as estate planning 101, when we were in school, we had if you were in college, remember, high school or college, there was class 101, 201, 301 as you went up, and we're doing a little bit more. I would think of the revocable living trust solely serving that purpose, not trying to do any more than that, as, revocable living trust use 101 or estate planning 101. If we want to move up a rung up to estate planning 201, we might be wanting to try to do a little bit more with our revocable living trust, which we can, and that would be to minimize Massachusetts estate tax. So yes, revocable living trusts, either joint revocable living trusts or his or her revocable living trusts, can serve both the purposes of avoiding probate and minimizing the Massachusetts estate tax, which will definitely be a topic for another day.
And if you come to us as a client, that's why we ask people to fill out a detailed questionnaire in advance. It's very helpful to know both your assets and your goals in guiding you whether you're just looking for probate avoidance or whether you want that extra benefit of the estate tax language in there. Okay, the next question is, how do you put valuable collections into your trust?
That's an excellent question because they're a thing, aren't they? I mentioned with a car's a thing too, and we call these things tangible assets, things that we can touch and hold on to or get into in terms of a car, I guess. We talked about how with a car, you do have to do something somewhere else, the registry of motor vehicles. Um, with your collections in your home, or even if it's your furnishings or it's your jewelry, um, you don't physically put them inside your revocable living trust. But what we can, and I will speak to the fact that as a practical matter, when you think about it, in a harmonious family situation, you have kids who all get along and they get along with you. They know where your personal effects are. They know where your jewelry is. They know where the furnishings are in the house. They can get into their house. And if your trust or your will said, uh, or whatever you leave, say, divide it up, pick and choose, share and share alike, draw by lots, who picks first, all of that, they'll execute that. They won't need the permission of a probate court to get into your house and do exactly that in a harmonious family situation. But just to make sure in our practice, and I think in many good legal practices, just to make sure that there's no question that those types of assets don't have to go through a probate process, we have what we call an assignment of personal property form that we use. We have our clients execute, where we list very generally all of your stuff and say that all that stuff is now officially titled in your revocable living trust. And that's meant as a backup to say, no, there's not going to be any probate of those things.
Are there any other questions right now? I don't see anything in the chat box, but feel free to raise your hand. Most of you I can't see, but raise your hand or add it into the chat box. Let's see. Oh, here we go. Okay. All right, I'm just going to read it. As opposed to taxable income that shouldn't have a trust as beneficiary given the higher tax rates for trust, would a Roth IRA, as opposed to a standard IRA, be a good candidate to make the trust the beneficiary of since it is non-taxable?
Yeah. Now, yeah, a Roth IRA would be an example of a type of an asset that, because it's not taxable as distributions are being made, the trust is a fine and better in most cases. We can't speak to every single case. This is why you want to meet with your lawyer and go over your specific case. But in most cases, the Roth IRA, like a home, like your bank and investment, your after-tax bank and investment accounts, are suitable assets to have designated into your trust at your death. Yes.
Um, and with that, thank you again for signing up. Thank you for everyone who are our clients. We really appreciate you. And goodbye.
Thank you all very much, and keep cool.